Can my employer cancel health insurance without notice? Imagine this. You go to the pharmacy to pick up a prescription, but the pharmacist says your health insurance was canceled. No notice, no warning, just gone. You call your employer, and they tell you the plan ended, or your coverage was dropped. Now you're left wondering, can my employer legally cancel health insurance without notice? Health insurance is one of the most important benefits for American workers, and losing it suddenly can be devastating. While employers sometimes have the right to make changes, strict federal laws regulate when and how coverage can end, and what kind of notice must be provided. In this video, we'll break it all down, what the Employee Retirement Income Security Act, ERISA, requires, how the Affordable Care Act, ACA, plays a role, what rights you have under COBRA, how state laws expand protections, and what workers can do if their health insurance is canceled without warning. Health insurance benefits are governed by a complex mix of federal and state laws. Employers have some flexibility, but they are not free to cancel coverage in secret or without following procedures. Let's walk through the main protections. ERISA, the baseline federal law. The Employee Retirement Income Security Act, ERISA, governs most employer-sponsored health plans. ERISA requires employers to provide summary plan descriptions, SPDs, outlining benefits and rules. Give advance notice of material modifications, usually at least 60 days before changes that reduce benefits. Maintain fiduciary responsibility, meaning they must act in the best interest of plan participants. If your employer cancels a plan mid-year or reduces coverage, they must notify you within 60 days. Canceling without notice is generally a violation of ERISA requirements. Example: a company switches health insurers and reduces coverage. Workers find out at the doctor's office. That's illegal if notice wasn't provided in advance. The Affordable Care Act, ACA, minimum standards. The Affordable Care Act, ACA, doesn't directly ban employers from changing health plans, but it sets important rules. Large employers, 50-plus full-time workers, must offer affordable health insurance to employees averaging at least 30 hours per week. Coverage must meet minimum essential standards, including preventive care and limits on waiting periods. Dropping coverage without notice may expose employers to ACA penalties. Example: a grocery chain with 100 employees stops offering health insurance altogether without notice. That can trigger federal fines under the ACA COBRA. Continuation of coverage. The Consolidated Omnibus Budget Reconciliation Act, COBRA, protects workers when coverage is lost due to qualifying events such as termination, reduced hours, or layoffs. Key rules. Employers with 20-plus employees must allow workers and dependents to continue coverage for 18 to 36 months. Employers must send a COBRA notice within 14 to 44 days of the qualifying event. Workers pay the full premium, but coverage must continue if they elect it. If your employer cancels health insurance after you quit, are laid off, or your hours are cut, you must receive a timely COBRA notice. Canceling coverage without notice violates federal law. Example: a restaurant worker loses health insurance after hours are reduced to part-time. The employer never sends a COBRA notice. That's a violation. When employers can cancel coverage, employers can legally cancel or change coverage in certain situations. Company-wide plan changes. Employers may switch insurance carriers or modify benefits, but must give notice. Non-payment of premiums. If the employer fails to pay the insurer, the plan may lapse, but workers must be notified. Employment changes. Termination, Resignation or reduced hours can end eligibility, but continuation rights apply. What they cannot do is quietly terminate coverage without informing workers in time for them to act. State laws. Added protections. Some states expand worker protections. California requires continued coverage during certain leaves, including pregnancy disability leave. Employers must also give written notice of changes. New York has mini COBRA laws applying even to small employers with fewer than 20 employees. Massachusetts requires employers to provide written notice when health insurance is terminated or changed. Example: in New York, a 10-person business ends its health plan. Workers must receive continuation options under the state's mini COBRA program. Discrimination and retaliation concerns. Canceling health insurance cannot be used as a tool for discrimination or retaliation. Under Title VII, the ADA, and the ADEA, employers cannot target employees based on race, sex, disability, or age. Example: an employer cancels coverage only for older employees to save costs. That's age discrimination and illegal. Similarly, canceling coverage after an employee files a safety complaint or discrimination claim may count as unlawful retaliation. Real-world cases. Case 1. A manufacturing company canceled its health plan mid-year without notice. Workers sued under ERISA and recovered back pay for medical expenses. Case 2. A small employer in New York failed to provide mini COBRA continuation after layoffs. The state fined the company and ordered coverage restored. Case 3. A hospital reduced health benefits without updating its summary plan description. The court found this violated ERISA notice rules. Case 4. A retail worker discovered coverage canceled after reporting wage violations. The employer faced retaliation claims under federal law. These cases show that canceling coverage without notice isn't just unfair, it's often illegal. What workers can do if your health insurance is canceled without notice. 1. Check plan documents. Review the summary plan description and notices. 2. Request explanation in writing. Employers must provide reasons for cancellation. 3. Look for COBRA rights. If coverage ended due to job changes, you should receive continuation options. 4. File a complaint. Contact the U.S. Department of Labor's Employee Benefits Security Administration, EBSA, or your state insurance department. 5. Document damages. Save medical bills, pharmacy denials, and correspondence. 6. Seek legal help. Attorneys often recover unpaid claims and penalties when employers break notice rules. Example: a worker denied coverage at the pharmacy gathers proof, files a complaint with the EBSA, and wins reimbursement for all out-of-pocket costs. The bigger picture. Health insurance is one of the most vital protections workers rely on. Canceling it without warning leaves families vulnerable to medical debt and treatment gaps. That's why laws like ERISA, the ACA, and COBRA exist, to ensure workers have notice, continuation options, and fair treatment. Employers may have business reasons to change coverage, but they cannot do it in secret. Transparency and notice are legal requirements, not optional courtesies. Workers who know their rights can push back and hold employers accountable when coverage disappears without warning. So, can your employer cancel health insurance without notice? The short answer is no, not legally. Under ERISA, employers must provide advance notice of plan changes. The ACA requires large employers to maintain coverage for eligible workers. COBRA guarantees continuation options when coverage ends, and many states add extra protections. The bottom line, your employer can change or end coverage, but they cannot leave you in the dark. If your insurance is canceled without proper notice, you may be entitled to reinstatement, back coverage, or even damages. If this video helped explain your rights, share it with coworkers. Knowing the law ensures that no worker is left without health care simply because an employer cut corners.